In 2007, the broadcaster Alexander Adonis was actually convicted for libel, and he actually spent 2 years in jail at least. Now, his case was submitted for review by the United Nations Human Rights Committee, and the committee actually exhorted the Philippine government and all state parties to actually decriminalize libel. Because in the case of Adonis, he was already sent to jail while the hearing on the case was progressing also. Can I proceed with the presentation? Just so we could put things in context. Okay. So I prepared some research on behalf of the editors and staff of the PCIJ. Thank you, sir, for this forum. You might call this meeting a great moment of history and courage, actually, for the Senate and the citizens of this country. The bills demonstrate your sense of history and of a major historical flaw in the democracy we call the Philippines that must be corrected yesterday, criminal libel. The bills demonstrate your sense of courage also to embrace and encourage thoughts and truths that journalists and netizens sometimes love to print. The critical, strident, unrestrained stories of our people and government that some politicians and people in power love to hate and send to jail. The proposed bills are all invariably very good. They seek to decriminalize libel. I will just qualify later in the case of the bill filed by Senator Onasan. There are now 11 bills filed by 8 senators that propose to decriminalize libel. It is in truth criminal libel an encumbrance and a clear and present danger to the full exercise of free speech, press freedom, and freedom of expression. Criminal libel is a restraint of law that has been with us for 84 years. Or since the revised penal code passed in 1930. It was a colonial edict that predated the birth of the Philippine Republic. So, I mean, I'm just putting in context the fact that if you decriminalize it now, you're correcting an 84-year-old flaw. And let me go to an illustration of a libel in the Philippines. The bills actually come at a time when, before we became an independent republic, the American colonial Commonwealth government were saying Filipinos were not yet ready for democracy and not good enough for a free press. The bills which you seek now to see pass will correct a law that in text and practice also mock the guarantees of Article 3, Section 4 of the Philippine Constitution that declares that no law shall be passed abridging the freedom of speech and of the press and of the right of the people to peaceably assemble for redress of grievances. Before 1930, of course, the first and most celebrated libel case in the Philippines is that which all Filipino students of journalism are told about, however, in sparse narratives of history books. The libel case involving Las Aves de Rapiña, Birds of Prey, an editorial written by Fidel Alejandro Reyes of the pro-independence and nationalist newspaper El Renacimiento. There is a lesson from history for us in Aves de Rapiña. The editorial was published on October 30, 1906, or 106 years ago. But while he was not identified by name, then Secretary of the Interior Dean C. Worcester actually filed suit against Reyes and the editors and staff of El Renacimiento for the editorial that largely criticized the U.S. colonial government, who he said, quote, "Besides being eagles have the characteristics of the vulture, the owl, and the vampire." They're not libelous per se, all those words, but they filed suit. The hearings lasted for several years, and the American status judge sentenced Reyes and the newspaper owner Martin Ocampo to 6 months in jail and fined them 2,000 pesos. Teodoro Calao, the editor of the newspaper, was sentenced to 12 months in jail and fined 25,000, but on appeal with the Supreme Court of the U.S. and the Philippines, never spent a day in jail. Pushed to bankruptcy by the enormous fines, El Renacimiento soon folded up. So this was a paper that was the platform for nationalism and independence of the Filipinos. It would be good actually to look at the very reason why Aves de Rapiña is so instructive to the present day. Fidel Reyes was a native of Lipa, Batangas, and even as a young man, he was driven to journalism. He wrote and volunteered for the Katipunan, and using their own resources, together with his friends, actually published a lot of stories. According to his great-grandchild, Mona Lavina, in a blog post in 2005, Reyes was actually very strident, but she particularly was described to be a man of mean temper, a dominating persona. So you might have them as, the politicians who are not so chummy and friendly and charming. He antagonized any known Filipino nationalist who would dare question or criticize him and anger the Philippine press with insulting statements about their intelligence and competency as journalists. In the mountains of Bukidnon and elsewhere, and in the company of indigenous peoples, Worcester felt like a king, quote unquote, and allegedly wanted to become the ruler of all non-Christians. Now, why do I like to look at Aves de Rapina as a case in point here? The Philippines' first libel suit had tackled that early on corruption in high office, mining and the extraction of natural resources, abuse of indigenous peoples, and collusive bidding and public contracts riddled with kickbacks, the very same issues that bedevil governance and development in the country to this day, the staple of a free press and a free online media. Imagine what could have happened if Reyes and his editors were not silenced and sent to jail. Maybe he would have been freed earlier. Now back to the future, the bills submitted in the Senate. On advice of our friends in the Free Legal Assistance Group, may we submit the following observations. Based on a preliminary screening of the proposed Senate bills, we like generally the theme that we must decriminalize libel now. Under the first set of the Senate bills, libel is no longer a crime. These bills seek the repeal of selected provisions of the Revised Penal Code and the Cybercrime Prevention Act. However, the bill filed by Senator Honasan is a bit different. Although it seeks to decriminalize libel, it may also be a bit dangerous because Mr. Honasan's bill requires A, professional organizations to register with the Securities and Exchange Commission and prescribe ethical standards, rules, and regulations governing the practice of the profession, including penalties for erring members. Mass media practitioners should be members of registered professional organizations. In effect, the message is no journalist or netizen perhaps may practice his or her craft unless he or she is a member of a registered professional organization. We admit that, of course, freedom does not always guarantee excellent results. We have good and bad writers, good and bad writing everywhere in the world. And in our profession, we acknowledge that we have a lot of work to do to actually rein in our ranks. But actually, you have to take the good and the bad together, as in all professions. I think the jurisprudence in libel has moved forward to even challenge the presumption of malice that is still in the Revised Penal Code. So now we talk about actual malice that have to be tested when the criticism is against public officials. Now, all the other bills are okay. And in particular, the bill of Senator Recto also repeals Section 4C4 of the Cybercrime Prevention Act. So under the second set of bills, libel is still a crime, however. Prescriptive period for libel is shortened to 6 months. Libel will not be punishable by imprisonment but by fine, and the author responsible for the printed article the author of the article will be responsible for the story. Now, two bills are almost identical. The bill of Senator Angara and Senator Jinggoy Estrada, 1387. So we submit libel in our history in the Philippine context has always been a political tool of the powerful and very often politicians. Typically a arrest-back action of people who had been criticized for wrongdoing. The common argument people are saying is, of course, a free press can be good or bad, but most certainly without freedom it will never be anything. Now, can I just bring in a few other points that are, we think, a matrix of issues that are important here. Libel and the right to reputation and the right to privacy are not antithetical constructs in law. Journalists respect the right to privacy of private individuals. So in journalism school, we teach our students that public officials, because of the principle that public office is a public trust, generally have no protection from privileged scrutiny by the media. Private persons, they have full protection. We are clear about this, and we have codes of ethics, media standards to govern us. Self-regulation works for the most part. It is not a perfect situation, but we know what we are doing, and I think it is best to leave to the journalists the improvement in ethical standards and compliance. Cybercrime law, the cybercrime law did not define the notion of online libel at all. although it raised the penalty to 1 degree higher. The cybercrime law did not even also clarify the standards of malice and how it could be discerned. It could happen, therefore, that under the cybercrime law, online libel could actually be filed against multiple authors in an online media newsroom when in fact it is the same story but only repurposed for the different platforms of the same network or the same newspaper agency. Now, the text of the revised penal code, the presumption of malice, has been interpreted more liberally by jurisprudence in the Philippines and elsewhere. So we do not think that it is actually important to just look at decriminalizing libel. It is probably the shortcut and the best solution to dealing with the unfortunate event that was the cybercrime prevention law. It is also important that to clarify that the libel provisions of the revised penal code are really old, ancient, and nowhere in the world almost being observed and followed. Most democracies have moved toward, actually civil suits against libel only, against journalists. Now, finally, criminal libel, we believe, puts the journalists and netizen under the thumb of the state, which files criminal libel suits on behalf of the injured parties. Typically, of course, the truth is politicians and the powerful make up the state or dominate the state. So why should the state now file suit against journalists who expose wrongdoing in the state or any of its entities on behalf of its fellow powerful politicians? We think the relief should be for civil suits to be filed against journalists. Fines in general are not also prescribed. In practice, the law says between 2,000 to 6,000 pesos, but millions of pesos had been actually quoted as damages claims of people in power. Recently, the first gentleman, the former first gentleman, of course, the former president, and of course, many others who are important political and powerful people in various communities, including, of course, recently, mining companies filing suit against bloggers. So what do we, the state should not be actually taking the side of people being accused of wrongdoing. And that, we think, is the very essence why criminal libel should not be anymore existing in any of our statutes. We believe it would be the best thing that the Senate could do if you pass this law, because it could also correct the unfortunate cybercrime prevention law. And we know the backstory of that law. It was supposed to be dealing with the ordinary crimes, and then libel was brought in. It is in a different ambit, civil and political liberties. So all of the bills indicate perhaps a recognition by the Senate that there was a mistake that had to be corrected in the Cybercrime Prevention Act. Thank you very much.
Thank you, Malou.